So welcome back, dear students. Today we are going to understand the meaning of writ of quo warranto. I am giving you one illustration that suppose I am teaching law to you in the GIMS Law College, and tomorrow onwards I purchased Ambassador car and started behaving like district magistrate of Gautam Buddha Nagar. There was a nameplate in front of my car. I borrowed few police officers also and started behaving like district magistrate and started checking the petrol pumps also. One of my student purchasing petrol pump, who was purchasing petrol at the petrol pump, he could identify me. He wished me and said, "Sir, you were teaching us law in the GIMS Law College, and how you have been appointed as district magistrate today?" I had no answer. So, if you want to challenge my appointment as district magistrate of Gautam Buddha Nagar, you can file a writ of quo warranto against me, because you know that I am teaching law in GIMS Law College. How I can be appointed district magistrate the very next day? So the object of writ of quo warranto is to prevent a person who has wrongly usurped a public office. I have wrongly usurped the public office of district magistrate Gautam Buddha Nagar. So I can be prohibited from continuing in that office by means of writ of quo warranto. This writ calls upon the person assuming the public office wrongfully to show cause to the court under what authority he holds the office. I will have to give explanation to the High Court when a writ is filed against me, under what authority I am holding that office. Where is my appointment letter? How I was appointed as district magistrate of Gautam Buddha Nagar very next day. Until today I am teaching as a law professor in GIMS Law College. You see, we have a very good illustration. One person of Assam Legal Services was appointed as law secretary, and then he was elevated as High Court judge. It's actually Manipur, not Assam. It is Manipur. One person of Manipur Legal Services was appointed as law secretary. Then he was elevated as a High Court judge. He was neither an advocate nor a district judge. Dear students, you know that for elevation of a High Court judge, you should be an advocate of 10 years standing or district judge or additional district judge of 10-year judicial services. So a writ of quo warranto was filed against this fellow, and he was removed from the office of High Court. So this writ cannot be filed against usurpation of a private office. Suppose I become the managing director of a private company. So this writ will not lie against me. The office must be a public office, like a High Court judge. This is another case, State of Assam versus Kusheshwar Saikia. In this case, the appointment of additional district judge was challenged. Dear students, I hope that many of you will become civil judge junior division after completion of your BA-LLB or BB-LLB degree. So I may tell you that your appointment as civil judge junior division can be challenged in a writ of quo warranto. You know, Article 233 of our constitution deals with appointment of district judges by the governor of the state in consultation with the High Court. And you also know that higher judicial services, HJS, with 7-year practice can be appointed as additional district judge by way of promotion from civil judge senior division, or if a person is having 7-year practice as an advocate, he can appear in HJS examination, and then he can be appointed as additional district judge under Article 233. But if there is some defect in his appointment, suppose on the date of filling the form, his 7-year practice was not complete, or his appointment as civil judge senior division was defective, or his appointment as civil judge junior division was defective, then that fellow can be removed from the office in a writ of quo warranto. He has to show cause to the court. He has to explain all the papers with the help of which he was appointed as additional district judge. These are the few articles dealing with appointment of district judges. 233 capital A deals with validation of appointment of district judges. 234 deals with recruitment of persons other than district judge to judicial services, and that shall be made by governor after consultation with State Public Service Commission and High Court of that state. Suppose you are going to be appointed as civil judge junior division or civil judge senior division, then this appointment shall be made by the governor after consultation with State Public Service Commission and High Court of that state. Similarly, Article 235 speaks about control of High Court over all subordinate courts. In 236 clause A, district judge is defined. 236B, judicial services are defined. Now coming back to the main point, that is the writ of quo warranto, is the writ which is issued directing the subordinate authorities to show under what authority they are holding the office. If a person has served a public office, the court may direct him not to carry out any activities in the office or may announce the office to be vacant. So quo warranto here means by what warrant or by what authority you are holding a particular office. If I am behaving as district magistrate of Gautam Buddha Nagar, then where is the warrant? Where is the authority? Where is the appointment letter? I will have to explain before the High Court or before the Supreme Court, wherever the writ of quo warranto is filed. So dear students, the quo warranto is a special form of legal action used to resolve a dispute over whether a specific person has a legal right to hold the public office that he or she occupies. If I have occupied the office of district magistrate, then I will have to explain how I have legal right to hold the public office. So quo warranto is used to test a person's legal right to hold an office and not to evaluate the person's performance in the office. And the total purpose of writ of quo warranto is to confirm the right of citizens to hold public offices. In this writ, the court or the judiciary reviews the action of the executive with regard to appointments made against statutory provisions to the public offices. Now, what are the conditions for issue of a writ of quo warranto? The existence of following factors have come to be recognized as condition precedent for the issue of a writ of quo warranto. The first condition is that the office must be a public office. This writ will not lie if I have served a private office. Second condition is that office must be an office of substantive character. That is, an office independent office and not merely the functionary or employment of a servant at the will and during the pleasure of another. If a servant is acting on behalf of his principal, then this writ will not lie against the servant. The office must be an office in substantive character. Third condition is office must have been created by the statute. It must have been created by law. These are the three conditions before a writ of quo warranto can be issued. So dear students, in nutshell, the writ of quo warranto is issued to an individual who has served a public office. He is asked through that writ about this right to hold the said office, and in reply to such writ, the person concerned has to legally prove his right to hold that office. Otherwise, court can get the office vacated. If I cannot show how I was appointed district magistrate, of Gautam Buddha Nagar, I will have to leave the office. Another example before you is that a person of 62 years has been appointed to fill a public office, whereas the retirement age is 60 years. See, the retirement age is 60 years and you are appointing a person of 62 years. So, in these circumstances, the appropriate High Court has a right to issue a writ of quo warranto against the person and declare the office as vacant office. Why? Because when retirement age is 60 years, how can you appoint a person in the age of 62 years to that office? That means that appointment is totally illegal. Once it is illegal, then the person whose appointment has been made, the appointment has to be quashed under the writ of quo warranto and office shall be declared as vacant. See, this is the case which I was talking to you in the beginning. Very good illustration of quo warranto before you. Please listen carefully. In Kumar Padma Prasad versus Union of India. This case was decided in 1992 by the Supreme Court. You see, one gentleman, Mr. K.N. Srivastava, was appointed as judge of the Guwahati High Court. He was LLB, no doubt. He joined as gazetted officer in the Law Department, Government of Assam in 1966. No problem, fine. In 1985, he was appointed as legal remembrancer and secretary law and judicial. He worked as LR and secretary law, DC judicial in 1987. Then he was shown to be a member of Mizoram Judicial Services. A petition of quo warranto was filed against him on the ground that he was not qualified for the office. He was elevated as High Court judge later on. Let me add this here also. Shown to be a member of Mizoram Judicial Services, he was appointed. He was appointed as High Court judge by the President of India. This line is missing here. So when he was appointed as High Court judge by President of India, then a petition of quo warranto was filed against him on the ground that he was not qualified for the office. Because for becoming a High Court judge, two conditions are required. One is that you should be an practicing advocate for 10 years, or you should have hold an office of judicial officer for 10 years. It was held by the Supreme Court in this case that since Mr. K.N. Srivastava was not qualified, he was neither an advocate of 10 years standing, nor he had the post of judicial officer for 10 years. So a writ of quo warranto was issued, and accordingly, the appointment of Mr. K.N. Srivastava was quashed. And the respondents were directed not to administer oaths to him under Article 219 of Constitution of India. This is a very good illustration of writ of quo warranto, where a person, see, was appointed as a High Court judge, and then his warrant of appointment issued by the President of India was cancelled, and the Union of India was directed not to administer oaths to Mr. K.N. Srivastava in terms of Article 219 of the Constitution. So see, like I gave you illustration that if I have served an office of district magistrate, Gautam Buddha Nagar, I can be removed under writ of quo warranto. Similarly, Mr. K.N. Srivastava, who was wrongly appointed as High Court judge because he was not holding the qualifications required for the office. The qualifications are that either Mr. K.N. Srivastava should have been an advocate of 10 years standing, or he should have held the post of a judicial officer for 10 years. So he was not having either of these qualifications. So in a writ of quo warranto, his appointment as High Court judge was cancelled. Then, dear students, now with the help of this illustration, I think that the concept of quo warranto is clear in your mind. Now let us see what are the features of a writ of quo warranto. The feature number one is prevention of wrongful usurpation of public office. The purpose of this writ is that nobody should wrongfully usurp a public office. Mr. K. N. Srivastava wrongfully usurped the office of a High Court judge, so he was removed in a writ of quo warranto. I, Dr. N. K. Behl, usurped the office of District Magistrate, Gautam Buddha Nagar. I can be removed under writ of quo warranto. So, dear students, the object of writ of quo warranto is to prevent a person who has wrongfully usurped an office from continuing in that office. The incumbent of the office is called upon to show cause to the court under what authority I am holding the office of District Magistrate, Gautam Buddha Nagar. And if I am holding the office illegally, court will issue writ of quo warranto against me to vacate the office. This is condition number one, feature number one, that there must be a wrongful usurpation of a public office for issue of writ of quo warranto. Second feature is office usurped must be a public office. See, High Court judge is a public office. District Magistrate is a public office. So Mr. K. N. Srivastava usurped a public office, High Court judge. I, Dr. N. K. Behl, usurped a public office, DM, Gautam Buddha Nagar. So in order to claim a writ of quo warranto, the office in question must be public office and is held by the usurper without legal authority. If District Magistrate is duly appointed by the government, he is an IAS officer, he has the appointment letter with him, he cannot be removed unless there is a defect in the appointment. And feature number three is public office and public interest. A public office means an office in which public is interested. The office of Speaker of a Legislative Assembly is a public office, and a writ of quo warranto can be issued to him to inquire under what authority he supported his claim to the office. If somebody challenges that the Speaker of Legislative Assembly or Speaker of the Lok Sabha, his appointment is not in accordance with law, so writ of quo warranto can be issued because it is a public office in which public is interested. Here is an illustration before you. GD Karkare versus TL Shevde. In this case, the petitioner applied to the High Court for issue of writ of quo warranto against Advocate General of the state. You know, Advocate General of the state is appointed under Article 165 Clause 1 of Constitution of India. So writ of quo warranto was filed against Advocate General of the state on the allegation that he was guilty of intrusion into the office of AG because at the date of his appointment, he did not possess requisite qualifications prescribed by the Constitution of India for that office. It was held in this case that a writ of quo warranto could be issued as office of AG, Advocate General, is a public office. Similarly, you have seen that appointment of High Court judge can be questioned in a writ of quo warranto. Then feature number 4, delay in filing the petition is immaterial. There is no question of delay in filing writ of quo warranto in which the right of a person to function in capacity is challenged because every day the person so acts in that capacity and a fresh cause of action arises daily. See, if I have started behaving like a district magistrate from tomorrow and I continued to do that work for 6 months, nobody noticed it. But one day one of my students noted. He said, "Sir, you are our teacher, you are our professor, you are teaching us constitutional law. How come you have been appointed as district magistrate at the age of 65? So a daily cause of action is arising. Delay is immaterial, even if the writ is filed against me after 5 years, 10 years. Because my wrongful usurpation of office is giving fresh cause of action daily to the citizens. Anybody can file a writ of quo warranto against me. Delay is immaterial. Feature number 5 is that writ of quo warranto is discretionary writ. None of the petitioner is entitled to relief as a right in a writ of quo warranto. It always depends upon the discretion of the court whether to grant the relief or not. It's not the right. It is the discretion of the High Court or the Supreme Court, as the case may be, whether to grant relief in a writ of quo warranto or not. Then, dear students, we have another very good case, Bajnath versus State of UP. In this case, a person was holding the post for a long time and there was no complaint against him, and the issue of writ of quo warranto would have been vexatious. The High Court, in its discretion, refused to issue writ of quo warranto. They said that a person was holding a post for a long time, there was no complaint against him, and issue of writ of quo warranto would have been vexatious, altogether a waste. So I told you this writ is discretionary. So High Court refused to issue writ of quo warranto in this case. Similarly, acquiescence on the part of petitioner may disentitle him to a relief in a writ of quo warranto. If you have a case, acquiesced your right. You have not bothered about your right since last, say, 20 or 30 years, and now you are going to file a writ of quo warranto after acquiescence. After acquiescence, your writ is likely to be dismissed. Then feature number 6 is office of private and public nature. I told you that writ of quo warranto does not lie against an office of private nature. It always lies only and only against an office of public nature. We have a very good leading case on this. Jamalpur R.A. Samaj versus Dr. D. Ram, decided by Patna High Court. In this case, petitioner moved the High Court for issue of writ of quo warranto against the members of working committee of Bihar Raj Pratinidhi Sabha, a private religious association. The writ was refused by Patna High Court on the ground that a writ of quo warranto does not lie against an office of a private nature. So this Rajya Pratinidhi Sabha was a private religious association, and writ cannot lie, writ of quo warranto cannot lie if a person has usurped the office